Welcome to Rebel Chaser. My name is Gail, and this video is from Judge Robert Springstead at the Newaygo Circuit Court in Michigan. He has a defendant in his courtroom who wants to vacate his jury verdict due to ineffective counsel. The problem is, he fired his attorney and he represented himself. So you get to watch that video. Also, the last video was not supposed to go out until 7 o'clock. For some reason, either I screwed up or YouTube screwed it up. I swear I didn't, but this video is supposed to go out directly after that, and that just didn't work. I'm sorry about that. I'll try it again probably tomorrow. Anyway, here you go.
All right, so this is case number 2213116 FH, People versus Daniel J. Weaver. Is represented today by Ms. Longoria. We've got some motions to take up before, and if we move on to sentencing, go ahead, Ms. Longoria.
Good morning, Your Honor. Diane Longoria appearing on behalf of Mr. Weaver. I did submit a brief in support of my motion. Initially, we had asked for an adjournment of the sentencing. However, I've had the opportunity to review the transcripts, and I did set forth in the brief some specifics as it relates to Mr. Weaver's motion to either for a new trial and or to set aside the verdict, get a judgment notwithstanding the verdict. And I would note that I do see that the prosecutor is arguing that he cannot argue ineffective assistance of counsel when he represented himself. However, the ineffective assistance of counsel that I argued was pre him representing himself, arguing that there were certain motions that could have been put in place and done to suppress evidence. If that evidence had not been had been suppressed, then there would be no case. Your Honor sat for the trial. You know, there was some residue found in a straw and that in an empty dresser, and that is the evidence that was used against Mr. Weaver. There is also was some questions that were brought up and issues regarding the chain of evidence and how the evidence was processed. I believe that there's a very good possibility that had a motion been filed prior to him representing himself, that there would be a good possibility that that evidence could have been suppressed and then the case could have been dismissed against him. So for the ineffective assistance of counsel, that would predate that. In addition to that, there were issues as it relates to him representing himself. He did not necessarily want to represent himself, but he wanted questions specifically asked that he wanted asked, and his counsel was not doing that, and so he felt compelled to represent himself to get the evidence out and presented as he saw fit, and found that that was the only way to do so. Because he was told, and Your Honor explained to him that he had counsel and the counsel should ask those questions. He was not able to get his counsel to ask the questions and the evidence to be brought out that he wanted out. So he has an absolute right for him to have the case brought to the jury in the way that he sees fit. He has the right through the United States Constitution as well as the Michigan Constitution to have the right of counsel, and that doesn't necessarily have to be solely represented by counsel, that they can co-counsel as well under People v. Williams. In addition to that, the question as to whether or not his due process has been violated by him representing through the process of how he ended up representing himself is under realistic appraisal of psychological tendencies and human weakness. pursuant to 273 U.S. at 532, 47 Supreme Court 437, and also under the Ohio laws in People v. Mayberry. In defining, they ask whether under a realistic appraisal of psychological tendencies and human weakness, does the interest of him representing himself pose such a risk of bias or prejudgment that the practice must be forbidden. In this case, with him representing himself mid-trial, I think it unduly biased him. Jury asking questions, why is he now representing himself? What happened to counsel? And clearly there was issues which he was not aware of that could have been brought up that were not brought up, issues that were brought up that shouldn't have been brought up. For example, that he was on parole at the time. They had made it clear in the transcripts off the record that they were not going to indicate that that's how the parole officer was there to see him. And so we would ask that there be a new trial and or a judgment notwithstanding the verdict, and that we not go forward with the sentencing because of the new trial and or a judgment notwithstanding the verdict. In addition to that, Mr. Weaver has also indicated that he believes, and this is not in my paperwork because this happened afterwards, is that there has been grievances filed in this matter by Mr. Weaver. He believes that that may also prejudice or skew his case by either your honor or the prosecutor.
All right, Mr. Stay.
There was two separate filings by defense, and I had sort of a difficult time parsing them out because they're sort of in almost a stream of consciousness. But I tried to do that for the court. As far as filing a motion to suppress the straw, the defense can't show that that's a violation of the performance prong Strickland. It's very unlikely that that would be successful because, as this court knows, chain of custody issues goes to weight, not admissibility, so it would not have been suppressed. Secondarily, the court or the jury heard all of the defects in that, so they were able to weigh whether that was important or not. It's not like none of that evidence came in. So as to Strickland, they can't meet the first prong. About obtaining an independent test of the substance, I mean, it's just a mere assertion. We have a substance that was seized and tested by the Michigan State Police lab that followed all the proper procedures. Defense counsel just saying, well, it could have been something else. There's no reason to believe that. And there's no reason, there's no way that she can show that that is a defective performance by defense counsel prior to trial. Now, self-representation issues are obviously a big part of this. This court, I reviewed the transcript. I didn't do the trial, and I reviewed the transcript thoroughly. This court went above and beyond explaining the risks of representing himself to the defendant. Okay, and at one point it was clear he didn't want to represent himself. But again, he asserted that right. The court followed the proper procedures. It's basically a procedure where the court needs to try to convince the defendant not to do it. And the court talked about all of these different risks that come with representing yourself. And he made an unequivocal waiver and decided to represent himself, which, as defense points out, is your right to do. Defense counsel indicates that he was forced to represent himself because there were questions that he wanted asked by defense counsel that would not be asked. Okay, but you have to put in a filing like this what those questions are. And if they seem like reasonable questions, possibly have a Ginther hearing as to why defense counsel wouldn't ask that. They may have hurt the defendant's case. They may not have been permissible questions. You can't simply just say, they wouldn't answer my questions. You have to make a more particular averment than that when you're seeking a new trial. That representing himself in the defense says that because he represented himself in the middle of trial, that this could have jaded the jury. But there's no case law to support that, or at least given by defense, why that would be true, or any facts other than just sort of a general assertion that because he represented himself, they wouldn't treat him fairly. I think it's clear from their questions that the jury took this case seriously before and after the defendant was represented by an attorney. The fact that he didn't ask for a directed verdict falls under the case of People versus Morton, which is once you decide to represent yourself, you can't then say I made a bunch of legal errors. And that's the same as to asking for a jury instruction for the lesser offense of use of methamphetamine. I don't think that should have been given in light of some of these facts. I think the court and the parties went over some of that during the trial. But again, you can't represent yourself and then say you're ineffective. And then the last point I think I saw in her motion was that he had to represent himself because, or the trial was defective because he could not call witnesses because trial counsel had not subpoenaed him. And again, this falls under the category, what witnesses? Okay, you can't just say witnesses. Were these witnesses? Are we talking about an alibi witness? Are we talking about somebody who was present for the search? You can't just assert, they wouldn't call the people I wanted to call and not put in who those people were. I think the court should deny this motion and move to sentencing.
All right, the court's going to take a short break, be back out. I'll reconvene about 11, and I'll come back and issue my rulings. And then depending on the rulings, then we may or may not proceed to sentencing. So we'll come back in roughly 15 minutes. Okay,
in addition, Your Honor, one thing that I did receive after this motion was filed, the fact that a defendant tries to agree the judge does not automatically mean the judge is biased and has to be taken off the case. If that were the case, if that were the state of the law, every client or every defendant would do that to avoid being sentenced in a criminal manner.
Thank you. All right, the court is denying all of the defendant's motions. So as to the issue, as to the moving to suppression of the straw as being ineffective assistance of counsel, as the prosecutor accurately points out, that any issues with the chain of custody or the testing would go to the weight, not to the admissibility of the evidence. That's pursuant to People versus White, 208 Mishap 126. On that point, the court reviewed my trial notes, and there was extensive questioning about how the straw was seized, how it was handled, where it was placed. Those issues were in front of the jury, and so they were covered by the defendant. And if the jury was so inclined, they could have found that any mishandling could have affected the results of the test. They did not, after being faced with that information. So that is not a grounds for ineffective assistance of counsel. It's not a grounds for directed verdict of acquittal. It's not grounds for a new trial. The independent test, the defendant's primary theory was that it was not his pipe. He insinuated that former roommate, Rosa, may have planted it in his room. But there were other statements that he may have smoked out of a pipe from somebody he didn't know, but he wasn't a snitch. He wasn't going to tell where he got it or anything like that. But his primary thrust was that this roommate must have planted it. So there was nothing in the test report that indicated that there was any abnormalities in the testing procedures. or that the substance wasn't methamphetamine. And for those reasons, the court finds that the failure to ask for an independent test is not ineffective assistance of counsel by any one of his prior counsel or by this defendant once he represented himself. The issue of self-representation, the court agrees with the prosecution that I did everything I could to advise Mr. Weaver of the risk of self-representation. Followed the protocols, followed the case law for doing that. Mr. Weaver's been down this road before. He's had at least one other case that went to the Court of Appeals on the same issue. So he knew what the risks were. He's been convicted when he was his own attorney on previous occasions. And on the prior appeals, the Court of Appeals had found that the proper procedure was in fact filed. And by advised him of the risks associated with it in extensive detail. In the court's opinion, he was trying to play some cat and mouse with the court as to, I'm forcing him to do this versus I want to have an attorney. He did ultimately say that no attorney was going to handle the case the way he wanted it to be handled, to ask the questions that he wanted to do it, and that he was going to represent himself in this case. As in the other case that went up on appeal, Mr. Weaver has a history of not getting along with lawyers. He had a different lawyer, in this case, a court-appointed lawyer. That attorney was removed. He hired an attorney. Couldn't get along with that individual. Wanted to fire her and represent himself mid-trial. So it's clear from the court that the defendant knew what the risks were, been through a trial before. He did a fairly good job of asking questions and raising the points that he wanted to make during trial. The court did find at the time, and I still believe that the defendant did make a clear and unequivocal request to represent himself. As the switch occurred from represented counsel to the defendant representing himself, the court cautioned the jury that informed them that the person has the right to represent themselves, that it's right in the Constitution that they have that right, and that they should not draw any negative inference from the fact that Mr. Weaver was choosing to represent himself, and that should not factor in any way into their decision. The court, as I was given that instruction, the jury was affirmatively nodding their head, agreeing with that instruction. As for the motion for judgment of acquittal after a jury verdict, MCL 76926 says that no judgment or verdict shall be set aside or reversed by any court in this state in any criminal case on the grounds of misdirection of the jury or improper admission or rejection of evidence or for error as to any matter of pleading or procedure unless in the opinion of the court after examination of the entire cause it shall affirmatively appear that an error complained of has resulted in a miscarriage of justice. I cannot find that this jury verdict was a miscarriage of justice. The straw that ended up testing positive for residue was found in the defendant's bedroom. He admitted that he used that room as a bedroom and that he had possessions in there. He did make statements that he was in the bedroom quite a bit. He made a statement that people are using in the house. I'm not around. He indicated that I don't use. Then he said maybe one time thing over a weekend, smoked a pipe from someone he didn't know. He said that he was not snitching on anyone, It was just a random one-time thing. That he said they indicated that he made a mistake. So certainly with the test in his, with the pipe in his room, with the admissions that he made, in the circumstances of this case, the court cannot find that there was a miscarriage of justice. The court would deny the motion for judgment of acquittal after the jury verdict. Then as to the motion for a new trial, the grounds essentially that were alleged in the motion I guess kind of dovetail with the ineffective assistance of counsel, which the court has already addressed. I did not find that for the time that he was represented by counsel that there was any ineffective assistance of counsel, as there's a strong presumption that issues of what questions to ask, what witnesses to call, and how to handle it are matters of trial strategy for the defense counsel. And then anything that happened after that, after Mr. Weaver was his own counsel, certainly he cannot claim that ineffective assistance of counsel when he was his own counsel. I've already addressed whether the verdict was against the great weight of the evidence. The court does not find that it was. So for those reasons, the court is denying the motion for the trial. I think I addressed all the issues that were raised in the motion, and I think it's appropriate now to proceed with sentencing. All right, Ms. Longoria, I'll give you 2 weeks to file a sentencing memorandum with all your challenges to the PSI, including any challenges to the history, any facts or circumstances that would support you challenging the accuracy of those. I'll give the prosecution 2 weeks after that to do everything they can, and the MDOC to verify it. There has to be fingerprints out there. There has to be, doesn't have to be, there could be court records that would support these convictions. And we're not talking about just one or two potential offenses that aren't attributable to this defendant. We're talking about 7 or 8 entries, which is a significant criminal history that I don't want to consider if it's not accurate. So I'm going to reset this case for sentencing again. Set it for April 9th at 9:20.
Thank you, Your Honor.
Thank you guys so much for watching, and I'll see you next time.